Common defenses to a criminal charge. A successful defense can prevent a conviction or result in a conviction of a lesser crime. It's not the criminal defendant's job to prove their innocence, it's the prosecutor's job to prove the defendant's guilt. But that doesn't mean the defense must sit silent during the case. An experienced criminal defense attorney holds many tools to use, from poking holes in the prosecution's case to raising defenses specific to the defendant's conduct or case. The prosecutor must prove the defendant's guilt beyond a reasonable doubt. If the prosecution fails to meet this burden, the jury, or judge, must acquit the defendant. Defendants don't need to prove their innocence. Still, they have the right to defend themselves by attacking the prosecution's case and trying to raise reasonable doubt. Even if the prosecution succeeds, the defense might be able to raise defenses showing that the case should be thrown out or the defendant's conduct was justified. Here are some commonly used defenses. The success of any defense will be case-dependent. Failure of proof defense. To raise reasonable doubt, defense attorneys try to poke holes in the prosecution's case by attacking the evidence and credibility of their witnesses. Witness testimony. To undermine witness testimony, the defense might try to show the witness was biased against the defendant or motivated to lie. Perhaps, the witness is a co-defendant who cut a deal with the prosecutor, agreeing to testify against the defendant in order to receive a reduced sentence. The defense could also point out inconsistencies or implausible circumstances in a witness's story. An eyewitness's limited opportunity to see the crime could be used to the defense's advantage as well. Evidence. Attempting to discredit the evidence can also hurt the government's case. The defense might introduce evidence showing someone else committed the crime. Or the defendant might present an alibi, a claim that the defendant was elsewhere at the time of the crime and couldn't have done it. Emphasizing the fact that no physical evidence exists can also raise doubt in the minds of the jurors. Although the prosecution doesn't need physical evidence to prove its case, juries often like to see something other than circumstantial evidence. Finally, the defense team could scrutinize and call out faulty or suspect police methods used in gathering or handling the evidence. Other defenses can include self-defense, defense of another, insanity and the statute of limitations, lack of specific intent, among others. If you have been arrested for or charged with a crime, contact a criminal defense attorney. One or more of these potential defenses might be applicable to your case and timing is of the essence. Thanks for watching.